I focus myself.
No. You see, when one reads a judgment, I told you the other day, I'm going to ask you about the facts, but I can tell you about the facts. Because the trial started on the 17th of September, 1999, in a place called Springbok. And do you know who the trial judge was?
No, I don't know, my lord.
Indeed, it was me.
The level of second-hand embarrassment I have for Advocate Mkabayi is beyond measure. Hi everybody, welcome back to my channel. This is Mzansi Unfiltered. Please remember to like, comment and subscribe. It absolutely brings me joy, and we're on the road to 60,000 subscribers. But back to the case, okay? The moment where Judge Nathan, okay, renowned Judge Nathan speaks isiXhosa and says, "Ndim." Oh, wow. I have been saying over several videos that something's not make sure with Mkabayi. She's unprepared and just argues from the bar, okay? AKA didn't prepare anything, or maybe, time constraints. Maybe she prepares but not fully, and therefore she always stands up. She always has this thing where she stands up and she reintroduces herself like nobody knows who she is and who she's representing. And, I find that hilarious, but I digress. So she's making an application for Section 174. For those who don't know, Section 174 means, hello, my client, in this case, Steffi, accused number 2, needs to be discharged as an accused person in this case, because what the hell, these charges don't match. There is no evidence that has been brought forward that implicates my client. And the judge says, what are you talking about? What do you mean there is no evidence? And she says, yeah, there's no evidence. And the judge says, okay, what about Miss Lombard? That's Laurentia Renz Lombard. And Mkabayi says she's not a credible witness. And the judge says, what test did you use to determine that? Oof. It was then that I knew it's time for her to give up. This is her time to reserve her dignity and walk away from this attempt, because once the judge said, what test did you determine that? Now, if you see the judge standing with or for Laurentia Renz as a credible witness, just know there's nothing you can argue over there, okay? There's nothing you could possibly argue. So guess what happens? Mkabayi continues, okay? And she quotes the Dondoni case, that happened in Springbok on the 17th of December 1999, and the judge says, I can tell you about the facts of that case, and I've warned you before that you must tell me the facts. First fact of the matter, who was the presiding judge? What does Mkabayi say with her full chest? I don't know. And what does Judge Nathan say? It was Ndim, okay? Spoken like a proud Xhosa. Not Judge Nathan saying, you know what, forget Afrikaans, forget English, I'm going to speak to you in isiXhosa. Oh my goodness. Still, it's like Mkabayi doesn't read the room. It's like she has to get whatever's off her chest. She doesn't adapt to the situation. The judge, Judge Nathan, was the judge in the case. You're trying to quote him, but you're misusing the case. And then she leaves that one because that one's never going to work. How are you going to tell the judge about his own judgment? So she moves over to some court, some other citation, and it's BACS. And the judge says, listen, I only follow authority of courts that are higher than this high court, which is either the Supreme Court of Appeals or Constitutional Court. Now, you're going to have to tell me what BACS stands for. And she's like, I don't know. Yet again, another I don't know from Mkabayi. Oof. And then finally she comes through and says, Botswana Supreme Court. And my lord says, don't take me to Botswana. Come back home. But I've given you the highlights, okay? Let you listen to it yourself. And let me find out from you what your thoughts are on Mkabayi. Because I think she failed Steffi yet again. She could have argued Section 174 and got a discharge for him, but she failed to argue it. Let's listen in, and I'll definitely catch you in the comment section down below.
Yes, thank you, Mr. Mkabayi. I am all ears.
Thank you, my lord.
Section 174 on behalf of accused number.
I am Ms. Mkabayi from Mkabayi Attorneys, and I confirm that I appear on behalf of Mr. Van Rijn in this matter. I further confirm that these are judicial instructions. Section 174 of the Criminal Procedure Act allows a court to discharge an accused person.
Ms. Mkabayi, you don't have to take me to what Section 174 says. You can go straight to your application on the basis that it is brought.
Thank you.
I think I'm well aware of what Section 174 says. You will have noted when you came here this morning that my Volume 2 was not on the bench. My Volume 2 of the TWA. And my registrar brought it in. I actually went to do the research on Section 174 last night and this morning. And I had a look at all the cases.
Thank you,
That's
my lord.
relevant.
Thank you, my lord. The defense will argue that accused number 2 has no case to answer on the following reasons. All the state witnesses that have testified in this case didn't bring any evidence that this court can come to a conclusion that accused number 2 has committed an offense.
All right, now, what about the evidence of Ms. Lombard?
The evidence of Ms. Lombard, my lord, it was not credible.
What is the test to be applied by a court if the defense bring an application relying on the lack of credibility of the state's evidence? What is the test that I should apply?
Whether that evidence is reliable.
What are the authorities that you rely on? Remember, and I'm going to assist you, right? In some instances, the credibility of the state's evidence can be a factor to be taken into account at the stage of a 174 application. Now, there's a number of cases. One can think of Shooping, which is one of them. A well-known case in this division will be the Diwani matter. And the comments made by Traverso DJP in that case. But we must go back to where it was articulated of how the test is to be applied. Now, what is the authority for the proposition that you raise? Remember, I told you on Thursday, counsel that appear before me knows I'm going to ask you. So what is the authority for the
authority,
proposition?
my lord, is based on the following cases. First case, as the court has already quoted it, State versus Shopping, State versus Tebula, State versus Lubata. There are two legs. That
Which of those cases are authorities in this division?
My lord?
Which of those cases that you refer to are cases in this division?
State versus Diwani is the case for this division.
Is it reported? Is State versus Diwani reported?
Even if it's not reported, my lord, but the principle.
I'm asking you whether it is reported. That's all I want to know.
Not yet reported, my lord.
Sure.
When I was
So if it's not reported, do you have a copy of the judgment? Did you look at the judgment?
I did, my lord.
Mm-hmm.
And it states as follows. State versus Diwani, 2014, in brackets, ZAWCHHC at 188, at paragraph 15. The legal position regarding the applications in terms of section 174 was summarized as follows. An accused person is entitled to be discharged at the close of the case for the prosecution if there's no possibility of a conviction, other than if he enters the witness box and incriminates himself.
That proposition is, of course, based on the Supreme Court of Appeal decision in Lubata, 2001. Did you have a look at that case?
Yes, I do have it, my lord.
What were the facts of the case?
Lubaka. The judge in that case was Judge Nugget.
Judge Nugent was
Nugent.
an AJA and Nafsa was an AJA in 2001. What were the facts of the case of Lubaka? Did you read the judgment?
I read the judgment, my lord.
Did you note who was the Judge Akwo in Lubaka?
I noticed it was Nugent.
No. The trial judge. Do you know who the trial judge was?
No, I didn't notice the
The
trial.
trial started on the 17th of September 1999 in a place called Springbok.
I focused myself.
No. You see, when one reads a judgment, I told you the other day, I'm going to ask you about the facts, but I can tell you about the facts. Because the trial started on the 17th of September 1999 in a place called Springbok. And do you know who the trial judge was?
No, I don't know, my lord.
Indeed, it was me. I was the trial judge in Lubaka, Akwo, and I sat in Springbok from the 17th of September 1999. But the facts of Lubaka is important if you base your argument on that. And the difference between that case and this case
Yes, my lord.
is stark, because it was the statements made by the co-accused. In this case, your client made a statement, and also wasn't discharged on all the charges, only relate to some of the charges. So I'm asking you, is that an authority for the proposition of the credibility issue?
I will argue, my lord, that the proposition in Shuping,
What year was Shuping?
my lord,
What year was Shuping?
I'll tell the court just now. Shuping was 1983, volume 2 SA, 109.
And where was it decided? Where was Shuping decided? Which court?
It's written BSC.
What does that mean? Which court was it deciding? Remember, we work on precedent. Which court was it deciding? Remember, we work on precedent. So I'm asking you, where was Shuping decided? Which court? I am bound to decisions of higher courts, which would include the Supreme Court of Appeal and the Constitutional Court and the full court of this division. And then you have judgments of single judges. I don't have to explain the law to you, but I'm asking you, where was Shuping decided? What does BSC stand for?
It's the Supreme Court, my lord.
Could you give me the full citation?
It's State vs. Shuping, 1983, volume 2 SA, page 109, in brackets BSC. In this matter, my lord, it was stated as follows.
No. I'm asking you, which court? What does BSC stand for?
It's the Supreme Court, my lord.
Which Supreme Court?
Botswana.
Am I bound? That was a judgment of Himstra J.
Yes, my lord. Himstra J rendered a judgment intended to provide guidance.
No, but I'm asking you which court. Because am I bound by a decision of another jurisdiction?
Yes,
If you're correct. But you see, Shuping was reported in 83-2. But there was a decision of this court, which was then the CPD reported, in volume 4 of 1983. To be precise, 1983, volume 4, page 262. And the ratio is to be found on page 263 at paragraph G, because in those days judgments didn't have paragraph numbers, so it was on the side. Do you know which case it is?
No, I don't know, my lord.
It's State versus Peter. Judgment was given by Williamson J.
I focus myself on the relevant matters for
No.
application.
That is specifically relevant. Because the dictum I'm taking you to deals with a test to be applied. And if you had read the judgment in Lubaka, you'll see it is also referred to there. Do you know what Williamson J. said in Peter? It's also quoted in the Tue, but he starts on close to the bottom of the page in the law report. And it's not a law report that's on Safley, because it's a 1983 decision. And the facts there was also a 204, so to speak. As was in Diwani, that's Laurentian Lombard. But I'm asking you, what was the test?
The test, my lord, is as follows. I'll start with the matter of shopping.
Don't take me to Botswana. Come back home. Come back home. And let's go to Court 1 in Cape Town. Because that's where the court sat in Peter. That courtroom in Court 1.
My lord, the test is one. The principle is one. In all the cases I've quoted, including the case that the court has just mentioned. First test is there sufficient evidence upon which a reasonable person can reasonably convict?
All right.
Number one.
So let's fast forward so that we don't waste time. Right. Let's accept the test that you can't tell me has been complied with as to credibility. Your client made a statement that I've admitted where he says he was with when JOSHLIN was delivered to somebody else. He went there to go and ask for his cut, his money. You saying on the evidence, even on his own that's been admitted, there is no evidence, because that's what the section says. There's no evidence on which a court may convict. And don't tell me about prima facie, because I don't know what that means in this context. I see the textbooks right about that.
I'll say that, my lord, boldly. The statement that has been admitted by the court, we heard yesterday that that version has not been corroborated. That version has not been supported. That version has not been confirmed. So the chain, my lord, has broken there.
So what?
So there is no evidence before this court.
Yes, is there anything else, Ms. Mkabayi, on the 174?
On 174, the second leg, my lord, on 174 is, it will be unfair if the accused person is brought into the witness box solely to supplement the state case.
Well, the test is, as I've just told you, is there a need for him to come and supplement the state's case? Because the test is no evidence upon which a reasonable court may convict, not must convict, nor will convict, but may convict.
I strongly argue and submit, my lord, that there's no evidence.
Thank you. Is that all?
That is all, my lord.
Thank you. May I have a seat?
Thank you.
Mr. Sivnarayan, are you ready?